Hey everybody, I'm Lloyd Chatfield and this is the Business Law Boot Camp. Today we're going to talk about some of the key employment law issues that companies deal with. But first, our standard disclaimer. This video is for informational purposes only, does not create an attorney-client relationship, and does not constitute legal advice in any jurisdiction. You don't have to watch, but if you do, you're agreeing to those completely reasonable terms. For most of my clients, employment issues make up a significant portion of their legal matters. I'm a firm believer that a successful company's most important asset is its people, and smart companies understand the law and how to handle employment law issues the right way. Over 2 decades of counseling companies on employment law issues, something like 90% of the issues fall into one of 2 areas: employment at will and wrongful termination, and workplace harassment and employee misconduct. There are obviously many issues other than these, but I want to focus on these areas where my clients have historically experienced the most issues. First, let's talk about employment at will, which is the predominant rule in the U.S. According to Paycor, virtually every state applies this rule in one form or another. Employment at will is a very pro-business policy and can provide some pretty harsh surprises for employees. The U.S. is really the exception globally. Most countries impose much greater limitations on firing employees than we do. My international clients, particularly those based in Europe, are often surprised to learn just how much latitude they have in getting rid of unwanted employees in the U.S. Conversely, my U.S. clients who expand overseas often pull their hair out when they realize just how much more protection most workers get around the globe than in the U.S. That is actually one of the reasons that a lot of U.S. companies will try to find alternatives to hiring boots on the ground overseas. So what is employment at will? Basically, employment at will means companies can fire employees for any reason or no reason at all. A company could, if it wanted to, fire all the workers born in summer, or those whose last names start with a B. They certainly don't have to provide a lot of due process to underperforming workers. They just cut them loose. And one thing to consider is that while employment at will specifically covers the right to fire, the unfettered right to fire workers generally includes the right to demote, to reduce pay, to change job responsibilities, etc. So while I'm going to talk mostly about terminations of employment, lesser adverse employment actions are also generally treated the same. As is often the case, the employment at will doctrine itself is pretty simple, but the exceptions to the rule can get a little tricky. This is an area that varies somewhat by state, but the basic exceptions to employment at will are the following. Number 1, discrimination. Federal law in virtually all states prohibit terminating people for reasons related to race, ethnicity, gender, age, pregnancy, veteran status, and disability. Some states extend protection to the LGBT community, while others protect categories of workers as diverse as smokers or gun owners against discrimination. Number 2, collective bargaining. One thing that unions generally secure for their members are some protections against arbitrary termination. Typically, a worker protected by a collective bargaining agreement can be terminated only for cause, which requires an employer to have a valid business reason. Number 3, employment contract. Most employees don't have employment contracts, but senior executives and in-demand talent often do enter into a contract that effectively overrides employment at will for that specific employee. Number 4, implied contracts. Some states will recognize exceptions to employment at will based on company policies or other statements or actions that are found to create an exception to employment at will. Obviously, you need to be very careful when drafting company policies to ensure you don't accidentally waive employment at will. Number 5, retaliation. Most states prohibit terminating employees in retaliation for reporting misconduct, asserting workers' compensation claims, or other legal rights. So employment at will is overridden if the real reason you're firing or disciplining an employee is retaliation for some protected action by the employee. And number 6, public policy. Some states limit terminations where the employer is acting against public policy. Some common examples are employees cooperating with law enforcement, reporting unsafe conditions, or pursuing legal rights such as workers' compensation. So odds are whatever state you're in applies employment at will, but the rule is not an absolute. The next major employment law issue that businesses confront is workplace harassment and employee misconduct. Harassment in the workplace has become a more serious issue in the past couple of decades. As a society and a legal system, we have made a decision that employees are entitled to a workplace that is free of harassment. So what is harassment in the workplace? Unwelcome verbal or physical conduct based on a person's race, color, religion, sex, or gender, national origin, age, or disability. Severe, pervasive, and persistent conduct that unreasonably interferes with an employee's work performance or creates an intimidating, hostile, or offensive work environment. An occurrence where an employee's status or benefits are directly affected by the harassing conduct of a manager or person of authority, or adverse employment actions, basically retaliation against employees who complain of harassment or discrimination or who participate in a complaint procedure. The idea is that employers have a duty to prevent harassment and are subject to serious legal liability if they fail to do so. One important consideration in harassment cases is that the victim's perception is more important than the perpetrator's intent. You may think you're making a harmless joke and have no ill intent, but if your conduct is offensive to someone else, you're likely engaging in harassment. I often tell my clients that the workplace should be rated G, even for those of us who are decidedly R-rated in our personal lives. Workplace harassment is one of the most common forms of employee misconduct, so we should take a minute to talk about how to respond to harassment and other forms of misconduct. I can't count how many employee misconduct investigations I've conducted over the years, but here are my key takeaways. Number one, a company should have a written policy that addresses employee misconduct, often as part of an employee handbook that outlines workplace conduct generally. Number two, a company should have a written procedure in place for employees to report misconduct, governing how investigations of reported misconduct are handled and outlining how disciplinary action will be determined. Number three, employees accused of misconduct should be presumed innocent, and employees reporting misconduct should be presumed to be acting in good faith. Number five, investigations should be conducted professionally and objectively. Involving legal counsel is important, at least for serious allegations, both to ensure a robust and fair procedure and to secure attorney-client privileges as much as possible. Every investigation should have a definitive outcome, which will generally either be that the claim was confirmed and a course of discipline was determined, or the claim was found to be unsubstantiated, in which case no discipline was deemed appropriate. Whether your business has 5 employees or 5,000, understanding the basics of employment law will help ensure that you can attract and retain the talent you need and ultimately that your business is successful. Having a great HR function backed up by competent legal counsel will help you get there. As always, thanks for watching the Business Law Bootcamp. We'll see you next time.